dear students. Today we will be dealing with the chapter relating to environment protection and law. First, the objectives of the chapter. The basic objectives of the lesson are to understand the objectives of Environment Protection Act 1986, to understand the powers relating to the central government provided under the Act, to understand the penal provisions relating to Environment Protection Act, and to understand the importance of rules relating to the Act. This Act authorizes the central government to protect and improve environmental quality, control and reduce pollution from all sources, and prohibit or restrict the setting or operation of any industrial facility on environmental grounds. Primarily, all powers under this Act are vested with the central government and the authorities constituted by the central government under Section 3, Clause 3. These include the power to take measures to protect and improve environment, the power to lay down the standards of air, water or soil quality for various purposes and areas, the maximum allowable limits of concentration of various environmental pollutants, the procedures and safeguards for handling hazardous substance, prohibition and restrictions on the location of industries and the carrying of process and operations in different areas. The Indian judiciary played an active role in Indian environmental cases, particularly relating to environmental pollution. Sooner or later, we will have to recognize that the earth has rights too, to live without pollution. What mankind must know is that human beings cannot live without Mother Earth, but the planet can live without humans. Eva Morales has stated this. The decline in the quality of environment has been a great matter of concern due to increasing pollution, loss of vegetal cover and loss of biological diversity, excessive concentration of harmful chemicals in the ambient atmosphere and in food chains, growing risk of environmental accidents and threat to life support systems. Some legislations relating to environmental protection have been enacted, that is, Water Prevention and Control of Pollution Act 1974 and the Air Prevention and Control of Pollution Act 1981. However, the Environment Protection Act 1986 was enacted under Article 253 of the Constitution of India with the view to implement the decisions of the United Nations Conference on Human Environment 1972. India participated in the conference and strongly voiced on the environmental concerns. While several measures have been taken for environmental protection both before and after the conference, the need for a general legislation considered further to implement the decisions taken in the conference has become increasingly evident. The Bhopal gas leak disaster of 1984 brought about the need for an umbrella legislation dealing with the environment as a whole. This led to the enactment of the Environment Protection Act 1986. The objectives and scope of the Act are to implement the decisions made at the UN Conference on the Human Environment at Stockholm, to enact general law on environmental protection which could cover uncovered gaps in the area of major environmental hazards, as the existing laws generally focused on special types of pollution or on specific categories of hazardous substances, and some major areas of environmental hazards were not covered. To coordinate activities of the various regulatory agencies under the existing laws and creation of authority or authorities for environmental protection, to provide for deterrent punishment to those who endanger the human environment, safety and health. Power of the central government to take measures to protect and improve environment. The central government has the power to take all such measures as it deems necessary for the purpose of protecting and improving the quality of environment and preventing, controlling and abating environmental pollution. Such measures may include measures with respect to all or any of the following matters, namely coordination of actions by the state governments, officers and other authorities under this Act or under any other law. Planning and execution of nationwide programs for the prevention, control and abatement of environmental pollution. Laying down standards for the emission or discharge of environmental pollutants. Restriction of areas in which any industry, operation or process shall be carried out. Laying down procedures and safeguards for the prevention of accidents which may cause environmental pollution and remedial measures for such accidents. Laying down procedures and safeguards for the handling of hazardous substances. Inspection of premises, equipment, material or substance and giving directions to authorities, persons and officers to take steps for the prevention, control and abatement of environmental pollution. The central government is also having the power to appoint officers to exercise powers and perform functions under the Act. A wide power has been conferred under Section 3, Clause 3 of the Environment Protection Act 1986 to the central government to constitute any authority to exercise powers and functions mentioned in the Act. The central government under this section can implement the suggestion of the Supreme Court for the establishment of environment courts, which alone should be empowered to deal with all matters civil, criminal relating to environment. Under Section 6, the central government may by notification in the official gazette make rules in respect of all or any of the matters which have been referred, namely the standards of quality of air, water or soil for various areas and purposes. The maximum allowable limits of concentration of various environmental pollutants, including noise for different areas. The procedures and safeguards for the handling of hazardous substances. The prohibition and restriction on the handling of hazardous substances in different areas. The prohibition and restrictions on the location of industries and the carrying on process and operations of different areas. The procedures and safeguards for the prevention of accidents which may cause environmental pollution and to provide for remedial measures for such accidents. Prevention, control and abatement of environment pollution. Section 7 of the Act specifically provides that no person carrying on any industry, operation or process shall discharge or emit or permit to be discharged or emit any environmental pollutant in excess of the prescribed standards. Section 8 provides that person handling hazardous substances are required to comply with the procedural safeguards. The Act also permits the central government to give any person powers of entry and inspection of any place for the purpose of examining and testing any equipment, industrial plant, record, register or document and make such seizures as necessary to prevent or mitigate environmental pollution. The power to take sample and procedure to be followed by the central government or any officer empowered by it in this behalf has the power for taking the analysis and samples of water, soil or any other substance. In order to make the result of any sample admissible in the evidence in any legal proceedings, notice must be served on the occupier or his agent or person in charge of that place. The notice must indicate the intention to have analysis of the sample. Sample must be collected in the presence of the occupier of the agent. Sample to be placed in the container which should be marked, sealed and should be signed both by the person taking the sample and the occupier or agent. To send the container to the environmental laboratory without any delay. The central government may establish or recognize one or more laboratories under this Act. The central government may also appoint or recognize qualified persons as government analysts. The report of the analyst can be used as evidence of fact stated therein in any proceedings under the Act. The penalties for contravention of the provisions of the Act. One of the objectives of Environment Protection Act is to provide for deterrent punishment to those who endanger human, environment, safety and health. Section 15 of the Environment Protection Act 1986 provides that any person who fails to comply or contravenes any of the provisions of the Act or the rules made or directions issued under the Act or rules, then for each failure or contravention he shall be punishable with imprisonment for a term which may extend to 5 years or with fine which may extend to 1 lakh rupees or with both. In case the failure or contravention contains, for first failure or contravention, an additional fine which may extend to 5,000 for every day can be imposed for a period during which failure or contravention continues. If the failure or contravention continues beyond a period of 1 year after contravention, the offender shall be punishable with imprisonment for a term which may extend to 7 years. The power to issue directions under this section includes the power to direct the closure, prohibition or regulation of any industry, operation or process. The stoppage or regulation of the supply of electricity or water or any other service procedure of the law. A complaint under this Act can be made by the central government or any authority or officer authorized by the government or any person who has given notice of not less than 60 days of the alleged offence and his intention to make complaint to the central government or the authorized officer. The court has the power to refer scientific and technical aspects for the investigation and opinion to expert body such as the Appellate Authority under the National Environment Appellate Authority Act 1997 and the power to direct the central government to determine and recover the cost of remedial measures from the polluter under Section 3 of the Environmental Protection Act 1986. The Act has an annexure of various rules required under various circumstances. The Environment Protection Rules 1986. The Environment Protection Rules seek to carry out the provision of Environment Protection Act and to meet various specific problems in relation to the protection and improvement of the environment. The Environment Protection Rule made the submission of an environment Audit report compulsory. Under the rule making powers of the Act, the Environment Protection Rule 1986 has been made. The rules provide the maximum permissible level of emission or discharge of environmental pollutants from industries. Some rules, important rules are mentioned below. The Hazardous Waste Management and Handling Rules 1989. The Hazardous Waste Management and Handling Rules 1989 specify all the things which would be considered as hazardous waste. Depending on their quantity, the things so specified include cyanide waste, mercury, arsenic, paints, pigments, glue, waste oil, asbestos, etc. Manufacture, storage and import of hazardous chemical rules 1989. These rules specify hazardous and toxic chemicals. Every person or firm who handles or deals in these substances has to identify the major accident hazards and take precautions to prevent accidents and limit their consequences to persons and environment. The Coastal Zone Regulations 1991. The central government in 1991 framed Coastal Zone Regulations declaring coastal stretches on coastal regulation zone and regulating activities in such zones. The Chemical Accidents Emergency Planning, Preparedness and Response Rules 1996. These rules were issued to strengthen the administrative response of the state and center to hazardous substances, accidents specifically. The Recycled Plastics Manufacture and Usage Rules 1999. These rules were introduced with the purpose to impose prohibition on the use of carry bags or the containers made of recycled plastics and to prescribe conditions for manufacturing the same. Biomedical Waste Management and Handling Rules 1998. It shall be the duty of every occupier of an institution generating biomedical waste, which includes a hospital, nursing home, clinic, dispensary, veterinary institution, animal house, pathological laboratory, blood banks, by whatever name called, to take all steps to ensure that such waste is handled without any adverse effect to human health and environment. The Noise Pollution Regulation and Control Rules 2000. The increasing ambient noise levels in public places from various sources, industrial activity, construction activity, loudspeakers, public address systems, music systems, vehicle horns and other mechanical devices have harmful effects on human health and the psychological well-being of the people. It is considered necessary to regulate and control noise producing and generating sources with the objective of maintaining the ambient air quality standards in respect of noise. Let us deal with the judicial activism of this Environment Protection Act. The important case relating to this act is Vellore Citizen Welfare Forum versus Union of India. This public interest under Article 32 of the Constitution has been filed by the petitioner and is directed against the pollution which is being caused by enormous discharge of untreated effluents by the tanneries and other industries in the state of Tamil Nadu. In this case, the Supreme Court has passed and issued comprehensive directions which are mainly given under: the central government shall constitute authority under Section 3, Clause 3 of the Environment Protection Act and shall confer on the said authority all the powers necessary to deal with the situation created by the tanneries and other polluting industries in the state of Tamil Nadu. The authority shall be headed by a retired judge of the High Court, and it may have other members, preferably with expertise in the field of pollution control and environment protection, to be appointed by the central government. The authority shall direct the closure of the industry owned or managed by a polluter in case he evades or refuses to pay the compensation awarded against him. A pollution fine of rupees 10,000 each on all tanneries in the districts as mentioned in the order was imposed, and same was to be recovered by the collectors or district magistrates. The authority, in consultation with expert bodies like NEERI, Central Board, shall frame the scheme or schemes for reversing the damage caused to the ecology and environmental pollution for the state of Tamil Nadu. Further, Supreme Court directed the Madras High Court to constitute a special bench, green bench, to deal with this case and other environmental matters. Another important case is Indian Council for Enviro Legal Action versus Union of India, famously known as the Pichri case. The writ petition filed by an environmentalist organization brings to light the woes of people living in the vicinity of the chemical industrial plants in India. In this case, the court held the central government constitutionally empowered to issue remedial directions, and it shall determine the amount required for carrying out the remedial measures. The closure of plant and factories which cause pollution in violation of the prevalent laws. Villagers of the affected areas are free to claim damages for the loss. Constitution of environmental court or tribunal or authority. Another case is relating to AP Pollution Control Board versus Professor M.V. Naidu, retired. The court directed that the Government of India should go about appropriate amendments in the environmental statutes, rules and notifications to ensure that in all environmental courts, tribunals and appellate authorities, there is always a judge of the rank of High Court judge or a Supreme Court judge, sitting or retired, and a scientist or a group of scientists of high ranking and experience, so as to help a proper and fair adjudication of disputes relating to environment and pollution. There is also need for amending the notifications issued under Rule 12 of the Hazardous Waste Management and Handling Rules 1989. Same applies to all other such rules or notifications issued either by the central government or the state government. The court observed that there is need to see that in the appellate authority under the Water Act 1974, the Air Act 1981 and the Appellate Authority Act under Rule 12 of the Hazardous Waste Rules 1989, under the notification issued under Section 3, Clause 3 of the Environment Protection Act 1986 for the NCT of Delhi, and under Section 10 of the National Environment Tribunal Act 1995 and other appellate bodies, there are invariably judicial and technical members included. Another case is Music Concert case, which was represented by M.C. Mehta versus Union of India. The petitioner filed the application seeking direction to take action against the authorities responsible for damaging and destroying the green belt within 500 meters of Taj Mahal, to direct the state of Uttar Pradesh to shift the venue of Yani concert beyond 500 meters from the Taj as recommended by the expert committee, to direct Union of India and the state of Uttar Pradesh not to allow any vehicles, generators or sound equipment within 500 meters of Taj, and a direction to constitute committee to take necessary steps to protect the green belt as directed by this court on the earlier occasion. Further, the court observed with regard to the pollution during night as per Schedule 3 of the Environment Protection Rules 1986, ambient air quality standards in respect of noise during silent zone should not exceed 40 decibels. Court on its own motion versus State of Himachal Pradesh. In this case, the court suo motu took cognizance of the reports appearing in a daily alleging havoc near Shimla on account of illegal mining and installing of stone crushers. The state government was directed to approach the central government for the creation of Shimla Environment Protection Zone. The creation of this zone was to complete within a period of 6 months. Notified, the miners were permitted to work in their mines and operate stone crushers till the creation of such a zone. They were also directed to strictly follow law, rules, etc. for prevention of environmental degradation. Further, the court imposed a ban on quarrying activity in the area after the Shimla Protection Zone. The court also directed the state government to rehabilitate miners to alternative sites by granting necessary permission. In addition, the operators were asked to contribute 20% of their gross profits to a fund to be used for restoring the scarred hills and afforestation. MC Mehta versus Union of India. In this case, MC Mehta objected to quarrying on ground of air pollution and violation of town planning regulations. The court ordered the closure of quarries in Delhi and in surrounding areas of Haryana. Asked the Haryana authorities to allot alternative sites in the new crushing zone located at the suitable distance from the capital. Though the Haryana government permitted quarry operators to relocate at new locations, soon the problem of atmospheric pollution was felt at the new locations also. As a result, the case had to be revived in the year 1995. The court gave fresh directions to the parties to arrange for water sprinklers and to install necessary pollution control devices. Further, the state government was asked to lay a road to the quarrying zone besides implementing the suggestions and directions given by the central board. The act though gives enormous powers to the central government to deal with environment related problems, but is still criticized on the ground that its radical approach regarding rule of locus standi is rendered ineffective. Because of the requirement of 60 days notice, which provides long time to the offender to make, alter and escape from the liability under the Environment Protection Act as per section 19b. Another issue is, though a bold step has been taken regarding no requirement of locus standi rule, but only the central government has been given the authority to collect samples of air, water or soil or other substance, and hence the aggrieved citizen or private agency will apparently have no means of proving that an offence has been committed by the alleged offender. Dear students, I hope you enjoyed this session. Next session, I will be dealing with the law relating to forests and the problems arising due to deforestation, which has been a great problem during the recent times, causing the problems relating to global warming and climate change. Thank you.